How do experienced lawyers build trust with clients? In this advanced legal English class, we'll focus on high level communication strategies like active listening, confidentiality, and building rapport. You'll also learn to use mixed conditionals and discourse markers to speak with clarity, empathy, and authority in client conversations. Perfect for legal professionals who want to master the language of trust. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community support and practice, join us in our Skool community. The link is in the description. Here's what we'll focus on in today's advanced class. First, you'll learn essential vocabulary for creating trust, words like rapport, confidentiality, and active listening. Next, we'll practice using discourse markers like frankly, to be honest, and as I was saying. These help you sound natural and structured in client meetings. We'll also work on mixed conditionals so you can speak clearly about hypothetical situations. For example, if the client had signed the contract, we wouldn't be in court. And finally, we'll apply everything in professional conversations where trust and empathy really matter. Let's begin. When you hear the phrase building rapport with the client, what comes to mind? Maybe you think about trust, that feeling when a client feels safe, understood, and respected. Or you think about connection, being able to speak clearly, listen actively, and make the other person feel heard. In legal practice, rapport isn't just about being friendly. It's about building a strong professional relationship that makes communication easier and outcomes better. Here are some ideas to get you thinking: trust, understanding, empathy, clear tone, body language, and professionalism. Now, let me share a few thoughts. To build trust, a lawyer should, I'd say, listen carefully, speak honestly, and show that they care about the client's goals. One thing that makes a client feel safe is being clear and calm, even when the topic is emotional and complex. And the best way to build rapport in English is, I would say, use polite, respectful language, repeat what you understand, and speak with empathy. Think about your own experience. What helps you trust someone? Let's use those ideas as we dive into today's lesson. Let's start with an essential word: rapport. Rapport is that natural connection you feel with someone when the communication flows easily, especially in professional relationships like lawyer and client. Imagine this: a new client walks into your office. They're nervous, maybe even angry. You listen calmly, make eye contact, and say, "I understand this is difficult." As the conversation continues, the client relaxes. They begin to trust you. That feeling, that bridge between you, that's rapport. It's not about being overly friendly, it's about being human, professional, and attentive. You build rapport by listening, showing understanding, and speaking clearly and respectfully. In legal work, rapport is the foundation of trust, and trust leads to better outcomes. Next, let's talk about a core principle of legal ethics: confidentiality. In law, confidentiality means that anything your client shares with you, whether it's in writing, spoken, or implied, must be kept private. This is not just a moral expectation, it's a legal duty. Imagine you're meeting with a client for the first time. They share sensitive details about a business deal or a family dispute. Even if they don't hire you, that information is protected. You're not allowed to discuss it with colleagues, mention it to friends, or use it to benefit another client. Confidentiality is what makes clients feel safe speaking to you. It creates space for honest communication. In many jurisdictions, breaking this duty can lead to disciplinary action, disbarment, or even lawsuits. So when you say, "as your lawyer, I can assure you that this will remain confidential," you're not just being polite, you're invoking a professional obligation and reinforcing trust. Now, let's look at a powerful communication skill: active listening. This goes beyond just hearing your client's words. Active listening means you're present, focused, and engaged. You're not thinking about what to say next. You're paying close attention to what they're saying now. Imagine this: you're in a client meeting. The client explains their legal issue. You nod, you make eye contact, maybe you paraphrase or say, "Let me make sure I understand. You're saying the company didn't follow through on the payment terms, correct?" That's active listening in action. You show that you're listening. You check for understanding. You reflect the speaker's concerns back to them. This does two things: it builds rapport. Your client feels heard and respected. It reduces misunderstandings, which is essential in legal work, where small details matter. Active listening builds trust faster than any legal term or polished phrase. It's not just about being a good communicator, it's about being a better lawyer. Let's talk about the word transparency. In law, transparency means being open and honest, especially about fees, timelines, risks, and outcomes. Imagine this: a lawyer tells a client, "This case may take up to 6 months, and if we lose, there may be additional costs. Here's a full breakdown." That's transparency. It builds trust because the client knows what to expect. There are no hidden surprises. The relationship starts with honesty. Being transparent doesn't mean telling the client everything you know. It means telling them everything they need to make informed decisions. Boundaries, an essential word in professional communication. Boundaries are the invisible lines we set to stay professional. Think of things like when and how clients can contact you, what you can or cannot guarantee. When a conversation becomes emotional or personal, let's say a client starts messaging you on WhatsApp at midnight, asking for urgent updates. If you respond every time, that boundary disappears. Instead, you might say, "For any legal updates, please email me during working hours. I want to give your case full attention when I'm in the office." Boundaries protect your time, energy, and professionalism, while still showing care and respect. Finally, let's learn reassurance, one of the most human parts of legal communication. Clients come to lawyers stressed, afraid, or confused. Reassurance means giving them confidence, not fake promises, but real, calm explanations. For example, a client says, "I'm worried I'll lose everything in the divorce." You reply, "That's completely understandable, but let's walk through your rights and what the law says. You're not alone. We'll take this step by step." That's reassurance. You acknowledge their fear, you explain clearly and calmly, you make them feel supported. It's one of the key ways we build trust in emotionally difficult legal situations. Let's start with a vocabulary challenge. Imagine this: a new client walks into a firm. She's nervous. She's never hired a lawyer before. The lawyer explains the case clearly, including the fees, the steps involved, and even some of the possible risks. She leaves feeling informed, not surprised, not confused. What word describes that clear, honest communication? Transparency. Transparency is about openness, sharing the truth, even when it's uncomfortable. It builds trust because clients know they're not being misled. Now, think of this situation. A client is stressed. They might lose their job. They don't understand the legal process and feel overwhelmed. The lawyer listens carefully, then says, "It's a tough situation, but we'll go through each step together. I've handled many similar cases, and you're not alone." What do we call that calm, comforting response? Reassurance. Reassurance means giving emotional support, not just legal facts. It helps the client feel safe and builds confidence in both you and the process. Here's another scenario. A client calls and starts sending WhatsApp messages at midnight. The lawyer gently responds the next morning. He says, "I'd love to help. Please contact me during business hours." That way, I can give your case the attention it deserves. What do we call these limits? These professional limits? Boundaries. Boundaries are necessary in any lawyer-client relationship. They help protect your time, reduce emotional burnout, and create a respectful, clear structure for communication. Let's look at a new group of words called discourse markers. These are words we use to connect ideas in conversation or writing, especially in professional legal communication. For example, however shows contrast. It's like saying but in a formal way. Therefore shows result or consequence. In fact, adds emphasis or correction. Although introduces something surprising or opposite to what we expect. You'll hear these in client meetings, contracts, legal emails, and they help you sound logical, persuasive, and clear. Let's say your client believes a lawsuit will be quick and simple. You've reviewed the case and want to gently explain that it may take time. We hope this case would resolve quickly, blank. There are several legal complications we must address first. Now, think. Which word shows polite contrast? The answer is however. However is a formal and respectful way to say but. Lawyers use it to introduce something that contrasts or disagrees with what was just said, without sounding rude or emotional. Here's a real legal scenario. A company failed to deliver goods on time. The lawyer explains the supplier missed two deadlines and didn't respond to our emails. Blank, we will file a claim for breach of contract. Which word shows that filing the claim is the logical result? Therefore. Therefore connects facts to their consequences. It helps you sound clear and logical when explaining decisions or legal steps. Imagine your client says, I don't think the employer broke the law. You respond, blank, the company failed to provide your severance pay or issue proper notice. You're gently correcting their idea. So, which word fits? In fact. In fact is used to add a surprising or important detail. It often corrects or reinforces the truth in a respectful way, useful when clarifying legal facts. Imagine this. A client followed all your advice and submitted their documents on time. Still, the court rejected their application. You explain, blank, the documents were complete and submitted early. The court rejected the request. What word introduces this unexpected twist? Although. Although shows contrast, especially when something unexpected happens. It's helpful when explaining outcomes that don't match expectations. Let's review everything with a real example. You're writing to a client about a hearing. You want to sound clear, logical, and confident. And these 4 discourse markers help you do that. First, the judge reviewed our arguments carefully. However, she requested more documentation. You're showing respectful contrast. Things didn't go exactly as planned. Then, we submitted all required evidence. In fact, we included 2 extra witness statements. Here, you emphasize your effort and correct a possible assumption. Next, although the opposing party objected, the judge accepted our timeline. This shows something unexpected happened and still turned out well. Finally, therefore, we expect the final decision next month. This connects the events to a clear, logical result. These 4 small words, however, in fact, although, and therefore, can make your legal communication powerful, professional, and persuasive. Let's talk about mixed conditionals. These are perfect for legal reasoning. In legal English, we often describe how something in the past led to a current problem, or how a better condition now could have changed something in the past. For example, if the client had followed our advice, she wouldn't be facing a lawsuit. This tells us the advice was in the past, and now there are legal consequences. That's past cause, present effect. Another example: if the clause were clearer, the contract would have avoided confusion. This one describes a present problem, unclear wording, and a past mistake that happened because of it. We call these mixed because the two parts come from different times, but they always connect logically. Let's look at each type more closely. Let's look at this powerful structure in legal English: mixed conditionals that show how a past event affects the present. We use this when something didn't happen in the past and that causes a problem or result now. Let's break it down with two examples. Number one: if the lawyer had filed the claim earlier, the case would be active today. Here's the story. Imagine a lawyer missing the deadline to file a legal claim. That happened in the past. Because of that mistake, the court closed the case, and now, today, the client has no active case. This sentence helps us express both parts. The past cause had filed the claim earlier, but didn't, and the present result, that the case would be active today, but it's not. This is very common in legal settings, explaining consequences of missed actions. Example number two: if they had reviewed the evidence, they would know what happened. Here's another legal situation. Let's say a legal team went to court without checking the full case file. That happened in the past. Now, in the present, they are confused about the facts of the case. This sentence lets us express that connection. Past failure: had reviewed the evidence, but didn't. Current problem: they would know what happened, but they don't. This mixed conditional helps lawyers, judges, and clients talk about missed actions that created present difficulties, a crucial skill in legal reasoning and client communication. Let's look at another important mixed conditional in legal English, one that shows how something that is true now caused a problem in the past. This structure is useful when reviewing contracts or explaining mistakes that already happened. Let's break it down with some examples. Example one: if this clause were clearer, the dispute would have ended sooner. Here's the situation. There's a contract clause that is confusing, and it's still unclear today. Because of that confusion, the dispute happened in the past, and it took a long time to resolve. This sentence explains the present condition: this clause were clearer, but it's not, and the past result: the dispute would have ended sooner, but it didn't. This type of sentence is useful in contract review, where a lawyer explains how a current problem, like unclear wording, created a delay or issue in the past. Example 2: if the contract included penalties, the client would have paid on time. Let's say a client paid their invoice late, and the business wants to know why. The lawyer reads the contract and realizes there were no penalty clauses. That's the present situation. Because the contract still doesn't include penalties, we now understand why the client was late in the past. So again, the present condition, which is the contract included penalties, but it doesn't, and the past result: the client would have paid on time, but didn't. This structure is excellent for legal analysis when you're explaining how a flaw or omission in a current document led to a past legal consequence. When you're speaking with a client, it's not always about talking more. It's about listening carefully and knowing when to get to the heart of the matter. This means focusing on what really matters in the case, the key legal problem or personal concern behind the client's words. For example, during the meeting, the lawyer gently got to the heart of the matter. The client was afraid of losing custody. In legal conversations, getting to the heart of the matter shows empathy and builds trust. Sometimes a client won't say exactly what they're feeling. They may sound fine, but their tone or silence says something else. As a lawyer, you often need to read between the lines. This means noticing what's not being said, the emotions, concerns, or unspoken fears. An example: the client said everything was okay, but the lawyer read between the lines and sensed hesitation about signing the agreement. Being able to read between the lines helps you respond with care and build deeper rapport. Legal meetings can be intimidating for clients. A good lawyer knows how to put someone at ease, to help them feel calm and safe. You might do this by using a warm tone, offering reassurance, or explaining things clearly. For example, the attorney put the nervous client at ease by starting with a friendly question and a smile. This small moment builds big trust. Clients want to feel informed and involved. A lawyer who keeps someone in the loop, sends updates, explains next steps, and checks in often. This idiom means making sure someone knows what's happening. It builds transparency, which builds trust. An example: the firm kept the client in the loop throughout the trial preparation, which made her feel supported. Using this idiom shows you value clear, ongoing communication. Now, I want to finish this up with telling you a story. I'm telling you a story about a missed opportunity to build trust. A new client came into the office, visibly stressed. The lawyer welcomed him and did her best to build rapport. She used active listening, repeated his concerns, and showed empathy. In fact, she took notes and asked thoughtful follow up questions. However, she forgot to explain the rule of confidentiality, something that's essential in first meetings. Because of that, the client held back on key details. If she had explained confidentiality at the beginning, the client would feel more comfortable sharing now. That's a missed chance to build deeper trust. Later in the conversation, she said, "Although your case is complicated, we do have strong legal arguments." And she concluded, "Therefore, I recommend taking action before deadlines become a problem." Still, the client didn't seem fully convinced. If the lawyer were more tuned in to emotional cues, she would have earned the client's trust that day. He left the meeting with doubts and eventually hired another firm. A senior partner told her, "You have got to read between the lines. Clients don't always say what they need. You have to sense it." Next time, she'll prepare better, hoping to get ahead of the problem before it becomes a missed opportunity again. Let's review what you learned today. First, we explored how to build rapport and trust with legal clients using strong communication skills like active listening. We talked about confidentiality, how explaining it clearly can help clients open up. You practice mixed conditionals, which help you express past mistakes and present consequences, a powerful tool for lawyers. We also learned how to use discourse markers like however, therefore, and although to create more fluent and persuasive communication. And finally, we added some natural, high level idioms like read between the lines and get ahead of the problem. Phrases that make your English sound confident and advanced. Keep practicing, and you'll build not just trust, but mastery. Even at an advanced level, legal English mistakes can cost you. Join our Skool group for expert lessons, live sessions, and practical support, and gain confidence communicating, drafting, and negotiating. The link is in the description.